session. With our presiding judge, Supreme Courtney, because all Tirols are related.
Calling the case of Bora Bora Wag Mong Ibura Company versus DENR. Are both sides ready? Let us begin.
Your Honor, the Philippines is a country blessed with natural resources, fertile lands, diverse flora and fauna, rich mineral deposits, and extensive coastlines. As an archipelago, the country has over 17,000 kilometers of coastline and territorial waters measuring as much as 1.67 million square kilometers, and we are home to over 2,400 species of fish. And for that reason, we are tasked to protect the ecology, our seas specifically, and that include our internal water and high seas, near, far, wherever you are. And with this task, we are called to be guardians, not of the galaxy, but of the galaxy. And we are called to be in touch with one of our premier Philippine tourist destinations. And we wish that it not be Mabora. We stand for the rehabilitation program as to overhaul the entire island of Boracay. Indeed, our president has observed its deterioration and has even went so far as to call it a cesspool, alluding the algae-covered shoreline and the filthy pits of liquid waste that can be found throughout, the entire coastline by not just officials, but also by tourists and residents themselves. And for this reason, Your Honor, in order to address the issues that I have presented, the President has issued an executive order ordering for the closure of Boracay for a rehabilitation period lasting 6 months, starting from April 26, 2018. We invoke the police power of the state in order to do so.
Is Attorney Richie Ong ready to present this case?
Yes, Your Honor. Your Honor, Boracay will never be mabobora for us. What the government essentially proposes is a grave abuse of discretion on 2 grounds. Sorry, wait, one second. Okay. First, the government cannot whimsically decide to close off an entire island as if they own the place. What about the LGUs? What about the business establishments? Will they be simply made to halt their operations entirely? To simply restrict people from coming and going from the island as they see fit? Your Honor, most businesses in Boracay are actually small businesses run by your average residents who employ their neighbors. Not only will the island cut off from Filipino citizens themselves, but depriving Filipino citizens of their freedom of movement, but also the entire island and its tourist industry will be deprived of income for residents, businesses, and even taxable income for the LGUs themselves. This is little more than an arbitrary deprivation of our economic freedom. Your Honor, the 6-month closure as ordered by the President is meant to address the issue of pollution. It's an environmental concern, granted. However, but by enacting such a radical measure, we will only create more problems than the problems it intends to solve, primarily economic. I mean, by depriving the LGUs and the residents of their income. Second, why must this initiative be by executive order? Doesn't such an issue fall under the jurisdiction of local government units? Can't the island cleanup be done on their own terms, as they see fit, not by some arbitrary power all the way in Manila who suddenly just comes in and decides what is best for them? I believe, Your Honor, that this executive order issued by the President should be declared a grave abuse of discretion and overturned. Thank you.
Ay, nako! Ang aming mga huli! Dapat ay rumami! May ibat na! Woo! Ang mangisda ay di biro. Laging buong hapon, nakayuko. But for me, nakaupo. Hindi siya biro. Let's stick to that. Mahirap siya, kuya, di ba?
bro. Yeah, bro, andito na ako sa beach. Kaso, bro, ba't gano'n? Ang daming basura, oh. Parang wala naman talaga ganito dapat sa beach. May straw. Saan ka?
Hoy! Bakit ka nagkakalat? Sino ka ba? Bakit ka nagkakalat?
Bro, di ako nagkakalat.
Anong bro?
I'm a tourist, bro.
Oh.
Nalagay ko lang yan dyan for safekeeping, bro.
Ano safekeeping? Bakit mo tinapon patalikod?
Sa ocean na yan, bro.
Ano? Yun yung ocean o bakit dito? Ako si Kapitana, kaya dapat hindi ka nagkakalat ng basura. Dapat nga malinis to lahat eh. Bakit ka nagkakalat? Turista ka na nga lang. Magkakalat ka pa dito. Hindi mo na nga to, di ba? Hindi mo na to lugar. Ganda ka? Indeed, mga ka-DDS. President Rodrigo Duterte observed the deterioration of the island, calling it a cesspool, alluding to the algae-covered shoreline and filthy pit of liquid waste sa Boracay. Our president blamed tourists like you for dumping sewage directly into the ocean. Kasalanan mo yan! Advance ka mag-isip, girl. Hindi pa nga natin nakikita kung talagang madumi naman yung dagat eh, di ba? Eddie, let's go and swim sa waters para malaman na natin. But before that, let's have a brief history of this wonderful, wonderful island. Ngayon, nasa inyo na ba yung mga papel ninyo para makita natin, ha? Okay na. Ano ako ng buhangin. Sina. Okay, let's start. Did you know that before, our seas were actually owned by the state?
Hanapin natin sa Philippine Constitution. Alam ko kasi, nasa batas natin,
Wow!
tawag sa kanya, Regalian Doctrine or Jura Regalian. Yung doctrine na yun, sinusundan yun ng Philippine Constitution. Tapos sabi dun, lahat ng lands, alienable and disposable by the state only, with the exception of agricultural lands. So, tignan natin sa Constitution natin kung ano nakalagay. So, sabi ng Constitution natin, sorry, sabi ng Constitution natin, ito yung basis ng laws governing natural resources ng country since 1935, 1973, and 1987. Sa first paragraph ng Article 12, Section 2 ng 1987 Constitution, yung exploration, development, and utilization ng natural resources, dapat under siya ng supervision ng state, bro.
Oh, sí, muy bien. Regalian Doctrine traces its root from Spanish colonialism. The court actually had the opportunity to explain how this legal concept have remained perennial in Chavez versus Public Estates Authority. The case involved PEA, or Public Estates Authority, which is the agency tasked to implement reclamation projects nationwide. Sa case na to, sabi ni PEA na they are looking for or they're seeking for the transfer of a parcel of land in Freedom Island and guess where? Manila Bay. And then the said transfer was challenged as the question reclaimed areas belong to the state. So sabi dito ni Supreme Court na affirm the reclaimed lands comprising of the Freedom Islands that are submerged of Manila Bay remain inalienable natural resources of the public domain. Sabi pa ng Supreme Court dito na ang origin nito ay nanggagaling sa, you know it, muy bien, from our Spanish colonialism. Traces back from that history.
Ang daming alam sis, and if owned nga ng state, hindi ka na pwedeng mag-own, di ba?
Actually, mga chong, pwede naman, pero kailangan yung mga agricultural lands yun, alienable by the state. Pero, yung mga forest lands, mineral lands, natural parks, and timberlands. Yun yung mga di pwede alienable. Hindi siya pwede pamigay ng state. Yun, sabi ng constitution.
Po ba na exclusive power, exclusive prerogative ng president ang mag-classify ng mga lands? Kaya nga powerful yung mga presidente ng Pilipinas di ba?
Totoo yan. Kaya sobrang powerful nung state natin considering na sila yung nagko-cover ng ownership ng lands. Since sila din yung nag-own nito, syempre, they are tasked with taking care of our environment, making sure that they protect it and maintain the ecology of our lands, not just the lands, but look there, and look back at me, the seas. Kaya, sa case na Oposa versus Factoran, nasabi ng court natin na Section 16 of Article 2 of 1987 Constitution is actually self-executing, which means it is a right basic since it concerns nothing less than the individual's self-preservation and self-perpetuation. A right that is assumed to have existed from the inception of humankind. Kaya napaka-importante nito. Diba ang laki niya? Big word na kailangan i-take care ng state natin ang ating mga kalupaan at take note. Balik sa akin. The seas. Na-mention kanina, ang executive lamang ang may power to identify what kind of land ang Boracay. Ano nga ba ito? Ano nga ba yon?
President Ferdinand Marcos classified the island of Boracay, among other islands, caves, and peninsulas in the Philippines as tourist zones and marine reserves in the issuance of Proclamation Order number 1801. And later, President Marcos operationalized this proclamation by way of Philippine Tourism Authority Circular 382. And the court had the opportunity to elucidate the significance of the said issuance in Secretary of the Department of Environment and Natural Resources versus Yap. To wit, Proclamation number 1801 or PTA number 382 did not convert the whole of Boracay into an agricultural land. There is nothing in the law or the circular which made Boracay Island an agricultural alienable land. The reference in circular number 382 to private lands and areas declared as alienable and disposable does not by itself classify the entire island as agricultural. Notably, circular number 382 makes reference not only to private lands and areas but also to public forested lands. Rule 8, Section 3 provides, no trees in forested private lands may be cut without prior authority from the PTA. All forested areas in public lands are declared forest reserves. In 2006, President Gloria Arroyo issued Proclamation number 1064, which classified Boracay into forest land and agricultural land pursuant to Presidential Decree number 705. The said executive order provides that 400 hectares of the island is reserved as forest land and over 628.96 hectares as agricultural land. Proclamation number 1064 was held to be constitutional, declaring 40% of Boracay to be state-owned and 60% as agriculture, which means it may be alienated, as provided in our constitution. Despite of the infrastructures developed in the island of Boracay, the classification provided by Proclamation number 1064 remains settled as held by the court in the case of Secretary of the Department of Environment and Natural Resources versus Yap, to wit. The court note that the classification of Boracay as forest land under PD number 705 may seem to be out of touch with the present realities in the island. Boracay, no doubt, has been partly stripped of its forest cover to pave the way for commercial development. As a premier tourist destination for local and foreign tourists, Boracay appears more of a commercial island resort rather than an actual forest land. Nevertheless, that the occupants of Boracay have built multi-million peso beach resorts on the island, that the island has already been stripped of its forest cover, or that the implementation of Proclamation number 1064 will destroy the island's tourism industry, do not negate its character as that of public interest. However, the court explained that owners with valid land titles since June 12, 1945, that they provided under CA number 141, could claim ownership to their properties in the island. Only the lands that are prescribed to be agriculture as defined under Proclamation number 1064 can be set up for land title registration. Furthermore, despite of such issuance of Arroyo's proclamation, the DENR has not conducted a cadastral survey to determine which of the Boracay lands are part of the reserve forest lands and which ones are agricultural based on the coordinates it provided. No such report exists, in sum. Provided the ownership of Boracay may be traced back to Proclamation number 1064, the next query aimed to be answered is whether the temporary closure of the island can be classified under the state's control. To provide legal basis, we recognize the inherent powers of the government, which include police power and eminent domain.
The three fundamental powers of the state are police power, the power of eminent domain, and the power of taxation. These powers are inherent powers and attributes and coexist with the state from the moment that the state comes into existence. Police power is the power of the state to regulate and restrain the use of liberty and property to promote public welfare, as explained by the court in Garocci versus Department of Energy. Police power rests upon two overarching necessities. First, upon public demand, and second, upon the right of the state and of the public to self-protection. In Churchill versus Rafferty, the court explained that its scope expands and contracts based on the changing needs of the public. The power of eminent domain enables the state to forcibly acquire private property upon payment of just compensation for some intended public use. The court in Barangay Sindalan versus Court of Appeals held that in the exercise of the power of eminent domain, it is essential that the taking of private property must be permanent and for public use. The requirement of public use means that the expropriator must use the property for the purpose specified in the petition. If this is not done, the expropriator must return the property even if there was no agreement for such reversal. But the owner must return to the expropriator the compensation it had received with legal interest and pay the expropriator for benefits the lot may have obtained. By the power of taxation, the state is able to demand from the members of society the proportionate share or contribution for the maintenance of the government. In environmentally focused cases, the government has frequently invoked police power under the premise that their acts are grounded upon public welfare and interest. In Oposo versus Factoran, the court recognized the public right of citizens to a balanced and healthful ecology, which for the first time in our constitutional history is solemnly incorporated in the fundamental law. The court held that this provision as a direct source of a right provides that the right to a balanced and healthful ecology carries with it the correlative duty to refrain from impairing the environment. This also supports that the state may invoke police power to achieve a balanced ecology. As to examine whether an initiative assumes a proper exercise of police power, jurisprudence laid down a validity test of police measure. Firstly, the lawful subject test. This provides that the interests of the public require the exercise of the power. Secondly, the test for lawful means, which validates that the initiative to be exercised under police power should reasonably employ means that are necessary for the accomplishment of the purpose and that the means should not be unduly oppressive. Thirdly, the test involves that the said initiative provides that the least restrictions of individual rights. For the power of eminent domain to be applicable, there is the taking of private property. The taking must constitute for public use, and there must be just compensation as to indemnify such expropriation. To conclude, this court reiterates that the island of Boracay is classified as 40% state-owned and 60% alienable and disposable as provided in Proclamation number 1064. The state may invoke police power in temporarily closing the island. However, the 6-month closure will also require shutdown of commercial establishments, affecting 30,000 workers and losing 1.96 billion due to non-entry of tourists. Determined to be within the grounds of police power, the government should not be forced to provide just compensation. However, the state must help the people affected from the closure of Boracay, grounded on the principles of parens patriae and based on equity. The remedy for the state in this case would be for the president to convert the whole Boracay as state-owned and for the president to reclassify this land based on police power.